Hi, welcome to Mondays with Melissa. Today I thought I'd give you a crash course in Advance Directives, which I feel like I talk about all the time, but apparently I haven't in a while on these Mondays with Melissa. So let's talk about power of attorney, healthcare proxy, and living will. A power of attorney is a document where you name someone to make financial decisions for you if you can't make them for yourself, if you can't handle your finances. So that could be anything from paying a bill, writing a check, to moving assets around and doing estate and Medicaid planning. But you have to make sure you have a good document. And I always tell people when I speak that if you have a legal size piece of paper that's back and front and that's your power of attorney, it is not a good document. It needs to be multiple pages. The documents have changed over the years, and most recently, you have to make sure you have a modification section that's completed. So the attorney who prepares your power of attorney has the ability to add modification language into the document. And we find as elder law and estate planning attorneys that this is so important because this is where we put all the language that allows your agent under a power of attorney to move assets around, to set up trusts, to move assets into a trust, to make gifts in excess of what the regular gifting laws say you can do, the IRS says you can do, so that if there's a need for care in a nursing home or at home, we can have the power of attorney getting these things done. So we always look at it with an eye towards long-term care planning and Medicaid planning, even if those things aren't necessary right at that moment. So it's really important to make sure you have a good document. Also, keep in mind you can have more than one agent under a power of attorney. You can name two people. You can choose if they're acting together or acting separately. So there's a lot of conversation and thought that goes into choosing your power of attorney and making sure that you have the right document. The next document is the healthcare proxy. Now in New York, you can only have one healthcare agent at a time. So even though you can list multiple people in the document, it's one person at a time. The doctors don't want to hear from 5 different people with 5 different opinions. Doesn't mean you can't make decisions together as a family, but there's going to be one spokesperson, one person the doctor's going to go to make healthcare decisions if you can't make your own. So doctor is always listening to you as long as you can still communicate what it is that you want. Even if you're hospitalized and have a terminal condition, as long as you can tell the doctors what it is that you want, they're following your instruction. But it's so important to have somebody on board as an agent to act on your behalf if there's an issue with dementia or Alzheimer's, some sort of brain injury, some sort of illness or accident that caused a problem that no longer allows you to communicate your wishes. And then we have the living will. And the living will is where you state your wishes regarding end-of-life decisions. So if you're in a situation where you have a complete loss of mental capacity, you're unable to eat or drink without assistance, or you have a condition that's likely to cause death in a short period of time, you can direct whether or not you want artificial measures taken to keep you alive. Do you want all measures taken no matter what? Do you want artificial measures to be withdrawn or withheld, like nutrition, hydration, etc.? So that document really serves as evidence of your wishes and instruction to your agent under the healthcare proxy. So it's not a controlling document in New York State, but it does take the burden off the family who could ultimately be making those decisions. These documents are the most important documents that you can have as a part of your estate plan, and I cannot stress enough that they are important for anybody who's 18 or older. This has nothing to do with health or being elderly or anything like that. This has to do with the fact that once you turn 18, there is no one with the legal authority to step in these financial and medical situations and make decisions or act on your behalf. Once you're 18, that's it. A parent no longer has that ability. There is no one with legal authority, not a spouse, not a child, not a parent. So make sure you have your advance directives in place and make sure you're getting them done by somebody who understands that this could be a document that's in place for a very long time, and you want to make sure all of your bases are covered no matter what. So reach out, ask any questions. We're always happy to have a chat. We offer free consultations in Melville and in Port Jefferson, and always happy to just talk about your situation and make any recommendations. Like, share, and subscribe to our page, and I will see you next week.